thoroughly go through each topic. Kila topic tukimaliza tuwe tumeifanyia justice. Let's start with topic 2, which is basically parties to a suit. We are starting with topic 2 because topic 1 is basically introduction. And the most important thing topic 1 brings with it is the hierarchy of courts, something that we already mentioned yesterday, or we had started to mention. Yesterday or the day before yesterday, criminal litigation. We had already started mentioning about the hierarchy of courts. Therefore, that is something that we should not let it take our time. Let us move to topic 2, which is on parties to a suit. We will start by defining the word party. A party in a suit is an individual, an entity incorporated, or a legal entity that can sue or be sued in its own name. It could even be an association of people that is not incorporated. However, a party in a suit is the kind of entity or individual that an effective decree cannot be passed without the involvement of that party in that suit. I repeat, when we are talking of a party in a suit, we are talking of either an individual, an entity, could be a legal entity that is incorporated or maybe unincorporated, but it can sue in its own name or be sued in its own name. It could also be an association of 1 or 2 more people, for example, a golf club, Rotary club, those kinds of things, that do not, because they are not incorporated, they do not have the legal capacity to bring cases in their own name, but they can have someone do so in a representative capacity. Nevertheless, a party in a suit can be looked at as that person or entity that an effective decree, an effective judgment cannot be passed unless we have that party involved in the suit, so that we can hear also what they have to, their interest in that suit. When it comes to locus standi on who can go to court in a civil matter, our guiding law is Article 258 of the Constitution of Kenya. Who is it that can approach the court on a civil matter? The same is under Article 258 of the Constitution of Kenya. I will read as follows. It is only 4 sentences. Number 1, that would be a person acting on behalf of another person who cannot act in their own name, a person acting as a member of or in the interest of a group or class of persons, a person acting in the public interest, or an association acting in the interest of 1 or more of its members. We are also told by Article 258, every person has the right to institute court proceedings where he or she may claim that certain rights that are due to him have been contravened. This, therefore, is the substantial definition of who a party is. It's important that every case contains the proper parties for that dispute to be heard effectively and to be said to be disposed. Therefore, parties in a suit may include the following. Number 1, natural persons like me and you, senior counsel, government, artificial persons like companies which are recognized under the law as legal persons or artificial persons. We can also have partnerships. We can also have trustees, executors, administrators. All these are part of what can be parties in a case. Let's look at them one by one, because there are certain things that are important to point out. The first party is the government. The government is a special party in most proceedings, or let's say in all proceedings. It is a special party because the government is there to represent so many people 52, 54 million Kenyans by virtue of the 2019 census. As a result, we just can't approach the court and sue the government, just like we would sue any other entity. This therefore brings to us the reality that when it comes to civil proceedings, suing the government means we will sue the Attorney General on behalf of the government. If we are sued by the government in a civil proceeding, we will also be sued by the Attorney General. One important thing, therefore, is that you cannot sue the government unless you serve it with a notice of intention to sue it. Notice of intention to sue. You cannot sue the government unless you serve it with a notice of intention to sue, which is normally 30 days. It is the expiry of that notice of intention to sue after the end of 30 days that any person can go to court and sue the government. Subject to this, it will not be possible for a person to go to court and sue. Natural persons. Natural persons are the most pacific parties in a case. They are the ones who appear more than everyone else. These are individuals like me and you, senior counsel, and you will realize natural persons, even though they are the most pacific or ubiquitous people you will see in the entities you will see in court, sometimes they suffer a limitation. They suffer a limitation or a disability that may not allow them to go to court. Number one, this may happen in the context of minors, people who have not yet reached the age of majority, which is 18. When we are talking of the age of majority, 18, this is a time when a person has legal capacity to sue or to be sued. Should a person not be of this age, they lack this capacity. As a result, any person who intends to sue and they are a minor, that suit can only be brought to court by a person acting on their behalf, who we will call the next friend to that minor. Next friend to that minor. The next friend is a person acting on the minor, on behalf of the minor. Mostly, this is normally a relative. In the absence of a relative, it could be generally a guardian, and so on and so forth. But we must understand one principle, that any person who is supposed to be a next friend should not have any of his own interests being adverse or opposite to those of the minor. That will be a conflict of interest. Any person who is proceeding to be able to institute proceedings on behalf of a minor, that person should not have any interests of his own that are adverse to that of the child. Number two, minors can also be sued. Minors can also be sued. If minors lack the capacity to come to court and present an issue in their own name, it therefore follows in the same principles that minors do not have the legal capacity to stand as defendants in court in their own name. I repeat, if a minor lacks the capacity to be able to sue in law in his own name, and a next friend must come in to represent him, the same principle extends to the reality that a minor also cannot be sued in his own name. If a minor is to be sued, he is to be sued through a representative again. But this representative, we will not call him a next friend. Instead, we will call him a guardian ad litem. Guardian ad litem. I have texted the name in your WhatsApp. A guardian ad litem is therefore the person who will be sued as a representative of the minor. The same way a minor will use a next of friend to be able to sue, a minor will use a guardian ad litem to be able to be sued. Other people who may lack capacity, natural persons, will be persons of sound mind. A person of sound mind cannot take a case to court by themselves. However, this has to be proved because in our laws we have something called the presumption of sanity, where everyone is presumed to be sane unless the opposite is proved. In this instance, therefore, it is important to be able to substantiate this unsoundness of mind to the court before we can have a person who is in a representative position to go ahead and sue on behalf of the sound mind, or the person who doesn't have a sound mind. Let's move to artificial persons or corporations, companies, or what we may call legal persons. When we look at companies, despite being recognized as legal persons, they do not really act on themselves. A company is therefore something fictitious, probably something fictitious, with only probably a building and assets and physical property that we can see. But when you see who is the company themselves, you may realize it all comes down to the agents. A company can sue, it can also be sued in its own name. However, when we are dealing with a suit, we must realize a few things. A suit involving a company, sorry. When we are going to court on behalf of a company or a company going to court, that must be something that should have been authorized by the company itself. Authorization by the company means either a resolution by the board of directors, who are the people having the power to authorize such a resolution, or a decision by the shareholders, who are actually the owners of that company. Therefore, in this instance, therefore, we can say a company proceeding to court, we must have a proper resolution, or the documents that are supposed to be signed when we are going to court, they must be executed by the proper individual of the company. This is someone who is authorized either by the decision of the board of directors, either by a resolution of the shareholders. It can sometimes be also either in the articles of association, of a company. The articles of association of a company, as we remember looking at the law of business associations, these are the constitution of a company. It's equal, they basically equate to the constitution of a company. The next entity that can become a party in court is a partnership. A partnership is quite something different, because even though the parties have come together and they may operate under a single name, you realize that a partnership can sue and be sued in its own name. However, in a partnership, we also have the option of being able to, even though we sue in the name of the company, or we may sue the partnership, we can actually have the particular partner who we have grievances against coming to court and not the other partner. We can sue the partnership because it is a separate legal entity. It's a company for all intents and purposes. However, one thing about partnerships is that a partner who is being specifically alleged to have done A, B, C, D, even then sued in the name of the partners, can also be asked to come forward in terms of defending the suit as part of the partnership. Finally, we have what we can call representative actions or representative suits in general. When it comes to representative actions and representative suits, I would want you to think about a situation where we have too many people, all who are affected by a particular issue, all who wish to come to the court. But then if they come to the court, we will have a long list of plaintiffs or a long list of defendants. Therefore, we can just have one person or a few of them, as long as it is the same claim, same cause of action, same facts, and a declaration of the court will affect all of them. We can only have 2, 3 people, or even one person coming to court as a plaintiff or a defendant to participate in that suit in a representative capacity. Once a decision has been rendered, that decision not only applies to this party who participated in the case, but also everyone else. Let's call this a representative suit. A representative suit, or an action by a representative. I also would want you to look at an action by a representative being not where we have a representative suit, but where we have a trustee who goes to court to sue on any particular matter involving the estate of a deceased. A trustee or an administrator or an executor is basically a personal representative of the deceased. At the end of the day, he is a representative for all intents and purposes. This is another way we can look at a representative. All these people have the power to come to court as a result. This is where we say, in general, these are parties to a suit. Having looked at them properly, we can agree as a conclusion that these are people or entities where we cannot have an effective judgment being passed by a court unless they are part of the proceedings, because they are affected by that judgment. They may have propositions or certain kind of arguments to make in that kind of suit. Therefore, they are a party, or they are supposed to be a party in the suit. Now that we have determined who parties are, it's important to understand that once in a while, we have a multiplicity of claims against one party, against another party. One party may decide to open a number of cases on different issues or on the same issue against a particular defendant. On one day, you breached the contract. On this other thing, you acted negligently. On this one, there is this and that. All civil claims, 3 different cases, which involve the same plaintiff and the same defendant. It could even be that we have a few employees of a certain company, all who have a case against the employer. Therefore, each one of them, kesi yake ni ya kuwa they have been released from work and procedurally, yet each one of them has filed a separate suit. You realize there is need for us to be able to join these suits together so that they can be heard as one, simply because they basically operate on the same principle. These are the same facts. This is the same defendant. These may be different parties, but we have the same cause of action. Therefore, to minimize extensive unnecessary litigation, we can bring together in what is referred to as joinder of parties. Joinder of parties. Joinder of parties is something very important because it helps us to be able to streamline cases and focus them. It helps us to avoid extensive unnecessary litigation. It helps us to be able to quickly, fairly, and in a timely manner dispose of a suit. That is, it is heard and determined. Joinder of parties, remember, it is whereby we have people, just take an example, one person may sue the same defendant multiple times for different things. If you are the same defendant and he is the same plaintiff, why can't we just have all these as one case? That's the first justification. The second justification could be different plaintiffs having sued in different cases against the same defendant. The example of a company that has laid off a few people and procedurally, then every party has gone ahead na amesuu kwa kesi yake. You realize at this point, it is just better, or it makes sense to be able to have what we call joinder of parties. Joinder of parties is said to arise, therefore, from the following principles. Number one, the parties must have a common interest. The parties must have a common grievance, and the relief or the prayers that they are seeking from the court naturally is the kind that, once given, basically applies to all these others. In this situation, it makes sense to save the court's time and bring everything to one so that we can have joinder of parties. Put them together and we proceed as one. There are conditions, however, which have to be met before we proceed on joinder of parties. Number one, we must have cause of action that arise from the same actions or the same transactions. The facts must be the same. For example, these multiple plaintiffs who go to court to sue because they believe they have been unprocedurally laid off at work, we can all see that the transaction they are claiming or the facts that they are claiming are basically the same. That is the first rule. The second rule is that a court reserves the discretion either to admit or to join. A court reserves discretion when it comes to joinder of parties. It may allow or it may not allow it. Joinder of parties can be started by a party who applies to the court for them to be enjoined in a proceeding, for them to be enjoined or for them to have certain kind of suits to be put together, or it can be done by the court on its own initiative. When it is done by the court on its own initiative, once in a while they use the Latin term suo motu. Suo motu. A Latin term that means, I have tapped it in the WhatsApp, a Latin term that means anything done by the court's own initiative, not having been applied by any person. So when you hear the court has acted suo motu, it means the court has acted on its own initiative and no one has had to apply. In addition to joinder of parties, the court can also undertake certain things like disjoinder of parties. Disjoinder of parties. Disjoinder of parties will happen whereby we have parties that are not substantive parties or proper parties in a suit. You know, some people are busybodies, like Okia Omtata. Okia Omtata, yule hata ukichemua kidogo, he takes you to court. Or small things, you'll find yourself in court. Now, in such an instance, therefore, we may, once in a while, we may have a person being a party in a suit, and they are not a proper party. Therefore, opposite to what we may call a joinder of party, the court may undertake a disjoinder of parties. Once in a while also, we may have what we can call misjoinder of parties. Misjoinder of parties. Misjoinder of parties will happen whereby a person has been mistakenly added as one of the parties in a case. Misjoinder of parties. In this situation, a court may undertake either removing that party, that is disjoinder, or it may enjoin the proper party. When it removes this wrong party through that had been who finds himself there as a result of misjoinder, now removed, the court could also substitute that party for the proper party. Let's call that substitution of parties. Substitution of parties. It is whereby the court has added the proper party and removed the misjoined party. At the end of the day, let's remember that it is the discretion of the court to join a party or to allow a party to join in a suit. But at the end of the day, it is also important to ensure that we have proper Yes, Counsel. So, sorry. It's a typo. Substitution of parties, not subscription. This is easy. Substitution of parties. Okay. So, at the end of the day, the court has what we call discretion to either decide to admit or not to admit. Finally, there is another kind of proceedings in court that we call interpleader proceedings. Interpleader proceedings. Interpleader proceedings will happen where two parties are claiming the same thing. Two parties are claiming the same thing. Senior counsel, you are at the center of this. In your position as a neutral authority, you hold certain property for certain two people who you are supposed to give to one of them. You know, for example, hii property niko nayo. For example, someone picks you as a trustee of his estate. You are an executor because you have been picked in a will. That if the day comes for me, I would want Senior Counsel Father Bosco to be my executor of my estate and ABCD, and these are my two children of who I would want the property to be given. So when that time comes, then you are the one in charge of doing all these things. The property, when you umeshikilia, you would want to give it to the rightful person. However, these people are in disagreement. Huyu anasema hivi, mimi ndio mwenyewe, mimi ndio nafaa nipate. Huyu mwingine anasema, mimi pia ndo nafaa nipate. Which leaves you in a dilemma as how do I execute my duty of giving this property to the person who is deserving or the person who is supposed to be the legal appropriate person? You can file a suit in court. You are at the center. You can file a suit for a proper declaration from the court on who is the rightful claimant between these two people and to who should I give this property. We will call this kind of proceeding an interpleader proceeding. It is normally filed by the neutral party who seeks to know from the court, who should I give this property? It is normally a declaration as to who is the rightful owner. Therefore, it is a direction by the court as to who you should dispose, pay, or give any of this property you have to that particular person. Let's call this an interpleader proceeding. Any question about this first topic on parties, Counsel? Very good. Let us move next. Sawa, no problem. This is an introductory one. It's an introductory one. Chapter 2. So these are basically the audio. Don't worry. We have good time. We will do this. So the second topic is on the cause of action. Cause of action. And we are asked, what is it? Very good. Let's go step by step. A cause of action can be described as a set of facts presented that reveal a person having had a certain right. This right has been violated, and according to the law, he has a relief that can be granted to him. A cause of action is basically a set of facts which, when put together, reveal that a person has had a right according to the law. This right has been violated, and there's actually legal redress that is available in law for them. We cannot approach the court without having a cause of action. It is the cause of action that will show. So haki yako ni gani yenye uko nayo? In what way can you show that hii haki yako ilikuwa violated? And does the law even provide you legal remedies? Because if you do not have these three things, there is no way you are coming to the court. This is what we call a cause of action. When we are talking of a cause of action, therefore, it can be said to have three ingredients. Number one, the plaintiff has a right, could be any right, in a contract, matters of negligence, it could be a constitutional right, anything. Lakini uko na haki yako ya kisheria. Number two, that right has been violated. That is the second ingredient. And number three, the defendant or the person who has done whatever they have done to you to violate your right, they are liable for it. This is what we call a cause of action. It is what takes us to court, or it is what makes us have capacity to approach the court. Should there be no cause of action, there will be nothing to be admitted. Senior counsel, you may have seen the day before yesterday, there was this very great lady who created a computer program that sent multiple emails to the emails Senate when it was receiving views on the finance bill. You must have noted that Jerry Yelene. So when this matter went to court, the charge sheet was produced. I'm sending a copy of the charge sheet, which I have with me. When you look at this charge sheet and you look at the offense alleged, there's one thing that will come out. There is no cause of action that has been revealed. When you look at what the lady did and what the elements of that offense alleged to have been, the prosecution has no cause of action. You cannot claim someone did A, B, C, D, or someone stole something, yet the actions you are describing do not amount to theft. You cannot say someone has done negligence unto you, yet the actions you have shown do not in any way amount to what is described in the laws as negligence. Therefore, the prosecution does not have a cause of action. The reason you saw Akina Faith Odhiambo, the president of the Law Society of Kenya, again in a screenshot that I captured, claiming that after inspecting this charge sheet, they realized the charge sheet is defective. It is defective because it does not reveal any cause of action. Bila cause of action, unaenda kotini kufanya nini? Unaenda kotini kufanya nini? Charge sheets, normally we have the name of the person who prepared the charge sheet. Imewekwa pale. Because according to the law, when these legal documents are prepared, we must know someone must take responsibility for these things. These are legal documents. In this charge sheet, no person in the ODPP office put his name. Therefore, yesterday and the day before yesterday, our social media was full of lawyers telling those who work in the ODPP, fellow lawyers working in the ODPP, what happened to your professional ethics responsibility? That you are able to be pushed by the government to construct the kind of charge sheets that do not reveal any cause of action. Nyinyi wenyewe hata mko na aibu ya yule mtu aliyetayarisha hii charge sheet kuweka jina lake. Who takes responsibility for this? Equity acts in personam. Who is that individual person? To whom responsibility can be ascertained for this charge sheet? Hakuna. So this has been the talk over and over. Otherwise, a cause of action is the most important thing because it's what gets us to court. When we are dealing with a cause of action, there is a way in which we must state it. We state a cause of action in a pleading. What is a pleading? A pleading is any document in which we put down our claims to the court officially so that it discloses what is it that brings us to the court, that is, what is our cause of action, how did it arise, and what do we want from the court. That document is what we will call a pleading. Therefore, when we are drafting pleadings or when we are dealing with pleadings, when we are writing our pleadings, what we are stating inside there is the cause of action. What brings us to the court? Now, there is a way in which we present cause of action. The most important thing to remember is that when we are dealing with presenting our cause of action, we simply start with, we apply what we can call deductive reasoning. Deductive reasoning. That is, We start with the major principles of law and we come down to the narrowest point. We start from the major principles of law to the narrower, the most little specific details. For example, look at this form of a cause of action that I may want to present to the court. Let's say this is an ordinary pleading I am writing. It could be any pleading. It starts this way. My title is Republic of Kenya in the High Court at Mombasa. Civil suit number 20 of 2025. Republic of Kenya. Republic of Kenya in the High Court of Kenya at Mombasa. Civil suit number 20 of 2025. This, the Republic of Kenya, is the country. We have the court. We have the case number. These are general issues. Let's call it the identification or title area. But these are the general issues at the top. We will then come to who the parties are, either as plaintiff or as defendant. We will put the name of the plaintiff, and then we will start mostly with the law that allows us to even come to court. The law that allows us to come to court, and then we will proceed with the description of the details. The plaintiff is so and so. He's a limited liability company based at this place and this place. The defendant is so and so, and he is based at this place where he works for gain. The defendant in this document, sorry, let me just use the word document because I don't want to specify the various pleadings. We will come to that at a later time, not to confuse anything. At this rate, then, you are getting into the specific details. For example, you may allege negligence, and you may go to the particulars of negligence. You may finish the particulars of negligence, and you may go to allege that this person has been cruel towards you, and you will go to the specific ones. You will finish with the reasons. Reasons wherefore I pray for the following prayers or orders from the court, and then you finish. What you have seen here is that you have done, starting from the general points to the specific ones. You started with Republic of Kenya, in the High Court of Kenya at Mombasa, civil suit number so and so. You are coming now to particulars, specific defendant, plaintiff, the name of the pleading. You've come to who the description detail. You've revealed your cause of action. Now umemaliza with your prayers. That is how we normally follow the script. From the general to the specific ones. From the general to the specific ones. Disregard the format I have used. Just understand that whenever we are dealing with cause of action, we start from what is general down to what is particular. We will see the format happening in all pleadings that we will be dealing with. However, another thing is also to understand that we normally give a summary of what happened. When we are dealing with a cause of action, we do not go extensively into the details, no. We only provide in summary form the details. Therefore, pleadings or any cause of action that is being said to the court must not include any evidence. Evidence itakuja wakati wa kesi inaanza. Therefore, you realize that when you are looking at a pleading and the cause of action that is there, that is stated, it is only a summary. Even in the charge sheet I have provided here, when you are told the particulars of the offense, utaona it is only a few words. The defendant is accused of having done this and this on this date at this place and so and so, without any evidence to it. We only provide it in a summary form. That is what we call cause of action. Sometimes we must be careful about these causes of action because they can be said to be frivolous. You type the word. They can be said to be frivolous. They can also be said to be scandalous, from the word scandal. These are the kind of pleadings that this is the kind of cause of action that do not reveal anything. You are coming to court claiming A, B, C, D, yet in truth, your cause of action does not show that you had any right in this instance. Or if it shows any right, it does not show how that right was violated. Or if it was violated, it does not show in any way who is liable. Sometimes there's no liability on anyone. Even though a wrong may have been done, there's still no liability on anyone. For example, if me and you, senior counsel, enter into a contract that I should supply you plastic bags and you will pay me a certain amount of money, and then it turns out that this is 2016. 1 year later, in 2017, Kenya ratifies an international treaty, which basically means Kenya now is bound to that treaty, and it decides to implement the removal of all forms of domestic plastic bags for use. Therefore, our contract has basically been vitiating factor. Yes, it was a right of mine. Yes, it has been violated, but who is liable? There's no liability. These are the kind of things that once in a while come up. We end up in court, and our causes of action can be described as frivolous, scandalous, even vexatious. In such instances, that cause of action will be struck out, will be dismissed, because it does not adhere to any of the rules which I have said in Tatu. Number one, show that any of your right has been, show that you actually had a right, the right has been infringed upon, and that there's someone or an entity that can be held liable. Just like we talk of joinder of parties, we can also have joinder of causes of action. It is actually very logical, because we could have instances where people have taken the same cause of action, different people have the same cause of action. Now wameenda kotini, wamefile cases tofauti, kila mtu kesi yake. Yet it's the same cause of action. Therefore, the same way we had joinder of parties, we can actually have joinders of causes of action. For example, University of Nairobi, right now his semester imepita. They had it was not even communicated to them officially, but the exams, they got information that the exams was to be online. Sorry, what to be physical. Now we are talking of people just like me and you, wenye wako mbalimbali. Kuna wengine hata wako Somalia, wanafanya kazi huko. Some are soldiers there. Some are working in NGOs in those northeastern areas. Wengine wako nje ya nchi mali kwingine. Therefore, physical exam, given the time that was there and everything, haingewezekana. They therefore went to court. Students representing ostensibly all three campuses. But apparently the way they drafted that cause of action turned out to be that it is only Parkland's campus yenye imepeleka kesi kotini. Therefore, when the ruling came, excusing these students who had filed the case in court, the court insisted it only applied to Parkland's campus students, even in class, because those are the people in this cause of action that have been able to raise this kind of thing. No other campus has been. Watu wa Mombasa campus felt left out. Watu wa Kisumu campus felt left out. They were planning also to go to court on the same issue, but a new case. Same facts, same everything, some cause of action, but a new case. It is in this instance whereby we have a ripe situation to have joinder of causes of action. Joinder of causes of action follows the same rules as joinder of parties. For example, you may see the following rules. Joinder of causes of action will happen whereby we have the same defendants, two people, three campuses, each one of them suing on the same causes of action, but the defendant is the same, the University of Nairobi. There is no need to have separate suits. We will join these three. Or the court will join these three. Sometimes, what we have is different suits that raise the same points, questions of law or questions of facts. The different cases in the same court against the same plaintiff, or against different plaintiffs, but which raise the same question of law and the same question of fact. What is a question of law and what is a question of fact? This is another important thing that we must bring out. A question of law is any legal issue which can simply be answered by the law. Is any legal issue that simply can be answered by the law. It does not need us to look at the facts. When we are having a question of law, is any question that the law can simply dispose of by us saying this and this provision, or we analyze the law and basically it provides us the way forward. That is a question of law. A question of fact is a question of fact, which for us to be able to determine, we need to look at the facts of that case. This is very important because when we are dealing with a case that is at the trial stage, you realize questions of facts are very important. But when we go on appeal, especially the second appeal, we will be told, here, we do not look at questions of facts. We will only look at questions of law. That is, was the law applied appropriately? That's what will happen, or what will happen in an appeal. Therefore, the distinction between what is a question of fact and what is a question of law is something very important. And once in a while, our lecturer has mentioned that this is something that could actually feature in orals. This is something that could actually come in the bar exam as part of something in between there. Therefore, any plaintiffs that may have the same question of law or same question of fact against different defendants may have their causes of action joined together. When someone is seeking to have these things put together, they seek leave of court. They seek leave of court. The word leave means permission. They seek permission of court because before they can proceed to do this. The court can also do so suo moto, that is, on its own initiative. Finally, the benefits of joinder of causes of action are the same as joinder of parties. Why? Because we are avoiding multiplicity of suits against the same defendant. We are reducing the amount of excessive litigation that is there. Meanwhile, these suits are actually related. Therefore, we are being able to deliver justice within a time that is reasonable. Finally, the court is the final, the court has discretion on the joinder of causes of action, the joinder of the causes of action. Any question, counsel, up to this point? Okay. Yes. It's actually a rule. Okay, when someone wants to have a joinder of causes of action, they file or they seek the leave of court. Leave of court means permission of the court to be able to do this. If you want to have certain causes of action to be joined, you can actually apply to the court. When you apply to the court, you do this as a result of, you first ask for permission from the court. Asking for permission from the court normally is basically through an application. Mostly, it is what we call chamber summons, which means applying to the judge in his office and in your application telling the judge, I would want this suit, which marries with that suit and that suit, to be put together. After all, they raise the same cause of action. You are applying to the judge.
We will call that normally a chamber summon. Don't worry, we will come to that because it's a form of pleading, but it is the way through which we apply to any small matters that do not need to be decided in court through the office of the judge himself. The office of the judge is what we call the chambers. Meanwhile, the court can also act suo motu, that is on its own initiative, if it realizes this suit and that suit and that suit raise the same cause of action. The court can therefore act on its own initiative and put these things together. Hapo tuko sawa, senior counsel? Very good, very good. In the next 7 minutes, let's start a little of the final topic, which is, I think, the most important. We will call this topic institution of suits. Now that we have a cause of action, how do we approach the court? Approaching the court takes into account a number of things. Number one, there are things we can call, or let's call them for purposes of our understanding here, let's call them conditions precedent. Things that are supposed to have been done before we go to court. These include sending demand letters where relevant. The failure to send a demand letter and just proceeding to court has the following legal effect, and it is the only one in law. If you fail to send a demand letter and you've just gone deep into filing a case, once the court is over and a judgment is given, you cannot be awarded costs. That is, the court will not give an order that the defendant pays for your litigation costs. That will not happen. Every party will meet their own costs just because of the failure of sending demand letter. Therefore, demand letter, notice of intention to sue where it is the government, this is part of the conditions precedent. These days, alternative dispute resolution has also been a big deal. Therefore, there are some cases whereby before you come to court, you're supposed to have attempted mediation out of court. It is until the mediation has failed that you come to court. Sometimes we have contracts with clauses that say, any dispute that occurs within this contract, we will first seek arbitration before we go to court. That arbitration must have been done and failed before you come to court. Does this court have any jurisdiction over this matter? Is there a similar matter of such nature arising from that particular issue that could already be in court or that is pending in court? All these things must be clear before we go to court. Let's call them conditions precedent. Therefore, very important to be able to know this, including the jurisdiction of the court also. Does the court have jurisdiction where you want to go? All these things, we will call them conditions precedent. Apart from these conditions precedent, we must understand that we have what we call a pleading, that is the document we use to approach the court in a civil case. At this point, the ways we use to approach the court, or the various forms of pleadings that we use to approach the court, are as follows. Number one, a plaint. Number two, an originating summon or originating summons. Number three, memorandum of appeal. Number four, a petition. Number five, a notice of motion. Number six, a chamber summons. These are the various documents, or what we can call pleadings, that we use to approach the court. Pleadings turn out to be very, very difficult things for many people. In fact, we had Counsel Elisha Ongoya coming to our class, teaching us about pleadings. And one thing he said is that pleadings are considered by many lawyers to be so difficult that if me and you, senior counsel, can push and be able to do well and master the art of drafting, we will already be in the top 10 of the lawyers in Kenya, because it is actually the most difficult thing for almost everyone. These documents we have before us apply to different situations. It is therefore important for us to know what is a plaint, what situations does it apply, what is an originating summons, what situation does it apply, what is a memorandum of appeal, and in what situation does it apply, and so on and so forth. When we approach these pleadings that way, and we look at the examples and the sections that must always be included, we realize that this thing is actually straightforward. Hakuna kitu ngumu. It is actually straightforward. For reasons of time, I will simply look at the memorandum of appeal by describing a few things about it. The memorandum of appeal is the pleading that we use anytime we are having an appeal. Therefore, it is only applicable in appeals and nowhere else. A memorandum of appeal contains two most important things. Number one, if you are appealing, you must give a notice of appeal to the court that had your case, and then prepare a memorandum of appeal to be filed at the registry of the court that you are going to appeal. If you are appealing, the pleading that we use is the memorandum of appeal. It is not used anywhere else. Number two, before you appeal, you must give a notice of appeal to the court that had your case. That is because anytime you have a decision that has been given or a judgment, you will be told you have 21 days to appeal. That means the judgment of the court is not active until after those 21 days. Therefore, if you wish to be able to appeal, you must notify the court so that there is the understanding this decision has been withheld until the appeal is done. The correct procedure, therefore, as part of this appeal process, is that you will file a notice of appeal to the court that had your case, and then you will prepare a memorandum of appeal to be filed at the registry of the court where you are going to appeal. We will call that a memorandum of appeal. The most important thing about a memorandum of appeal is that it will quote the parties, it will quote the case number, it will bring out the arguments for that appeal, which we call the grounds of appeal. Every pleading contains arguments and allegations. Remember, these are just mere allegations. Therefore, you must be able, senior counsel, to account for what you have alleged. You must show a seriousness in what you have alleged. Therefore, every pleading must be accompanied by what we call a supporting affidavit or a verifying affidavit. Simply to say, I, senior counsel Father Bosco, I am an adult of sound mind. Everything I have said in this, to the correctness of these avowals, is true to my understanding. On this and this day, or on this and this part, this is what happened. Therefore, I swear these information I have provided to be the truth of what I know. Supporting affidavit to support your allegations, because what you have said in the memorandum of appeal or any other pleading, it's simply allegations. Therefore, no pleading stands without a supporting affidavit, or which we can call a verifying affidavit. It is the same thing. A verifying affidavit will come where we are using certain kind of pleadings to verify what you're saying. A supporting affidavit will come to support what you are saying in certain pleadings, like a petition. But it is the same thing. Therefore, we cannot have a pleading without a supporting or verifying affidavit. In this instance, the pleading we've talked about is a memorandum of appeal. Generally, when you look at all these pleadings, they will follow a certain format. The first format is that they will have a title. The title is what you see as New Republic of Kenya, in the High Court of Kenya at Mombasa, civil suit number so and so of 2015. That is all. Always make sure your pleadings have a title. Number two, the parties. Who are the parties? So and so versus so and so. This one is the plaintiff, this one is the defendant. Tosha. If you're suing a company, make sure you correctly name it. When you're suing a minor, make sure it is shown that we are suing this guardian ad litem on behalf of. This is the minor suing on behalf of the next friend. Let it be there. Also, be up to date with who the names that are supposed to be used. For example, when we are appealing, you are the one appealing against me. You become an applicant or appellant, and I will be referred to as the respondent. In the main suit that was heard at the lower court, you were the plaintiff, I was the defendant or the respondent. So these terminologies are important to be able to know. Once we are done with that, we must know that there are three different ways in terms of complexities of these courts, of these documents. You can have a small claim, a fast track, and a multi-track. You will quote on which of these three does yours fall, depending on the complexity. Either fast track, multi-track, or small claim. And then below that, you will give us the title of your pleading. In this case, you will write memorandum of appeal in capital letters. And then you go deep. That is just the title. The second part of your pleading normally is the description. The description is normally point 1 and point 2. Remember, all pleadings are numbered 1, 2, 3. Therefore, number 1 and number 2 is normally the title. The plaintiff is an adult of sound mind who resides in Mombasa at this and this place where he works for gain. Number 2, the defendant is a limited liability company based in Nairobi, PO Box so and so. Service of someone shall be effected through the defendant's advocates. What have you done? Simply describe who these parties are. That is normally number 1 and number 2. After that, we go to the cause of action. Now you have told us who is the defendant and who is the plaintiff. So what? Provide for us the cause of action. On the 4th day of May 2024, at around 2 p.m., the defendant engaged in this and this and this action. This action amounts in law to negligence. Particulars of the negligence are as follows. A, B, C, D, mpaka unamaliza your cause of action. Once you're done with your cause of action, there's something I will mention. When we come to looking at pleadings, you will realize certain allegations must be pleaded specifically. Therefore, when you mention something like negligence, you must show us the particulars of negligence. When you talk of breach of contract, you must show us the particulars of breach of contract. This is what we mean when we are told, plead these certain things specifically. That is, give us the specifics. We will see it does not apply to everything. We will see what is it that whenever it comes in a pleading must be specifically pleaded. Once you are done with your cause of action, the next thing are the conditions precedent. Indicate, I confirm that there is no pending suit before any court on this matter. I confirm that demand letters were sent, copies of which have been attached, but the defendant was not able to comply or refused to comply. Number 3, I confirm that this court has jurisdiction on this matter. These are the conditions precedent that we see. They normally come after the cause of action. And finally, the prayers. Now that you have told us of all this, what are you asking from the court? Reasons wherefore I pray to this court for the following orders or remedies. A declaration that my rights were violated, to be awarded damages, special damages to this amount, general damages, and any other court, any other order or remedy the court may deem fit to grant. Every pleading must be signed and dated by the person who prepared it. Because we need to have someone take responsibility for any other kind of thing, for any of these things noted inside here. Therefore, after the prayers, you will see dated, prepared, or just the name of the advocates who prepared it. So you will see dated on this date at Nairobi, 2015. Father Bosco, Senior Counsel, advocates for the plaintiff. He will then come a small part which will show the law firm that prepared this, Father Bosco and Counsel, LLP, PO Box so and so, prepared by Father Bosco and Senior Counsel LLP. This place, PO Box so and so, this building, 4th floor. And then finally, to be served upon this Thomas Mlanda, PO Box so and so, this location, this floor. Your pleading is over. Hakuna kitu nyingine. As simple as that. You simply need to know what is the name of the pleading, which context does it apply, and then we have a specific format that we can go point by point, from description to the title, to the cause of action, to the conditions precedent, to the prayers, to the person who prepared these pleadings and the date signed, the advocates for the person who prepared these, and who it should be served upon. We shall. What people call drafting, and they make it a big deal. It is not at all a big deal. Sivyo tu. So, yes. Yes. No problem. Hata usijali, the next topic on civil litigation, now we will look at this particular plea. So we will go deep now into a memorandum of appeal and all this, don't worry. Yes. 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 Sawa, Counsel, no problem. Tomorrow is a holiday. Are we on? Mimi niko on. I don't know about you. Yes. Yes. Okay, I can add it, but trial advocacy is one of those soft ones. Utaona tu, it's soft. Ni kama legal practice management lecturer wetu anatuambia, you have to prepare coffee for you have to have a place for coffee for your staff, you have to have a microwave. Akanajiambia, hey, what am I writing? What are we hearing? Yes. No problem. No problem, Counsel. Yeah. Thank you so much, Counsel. So tomorrow we are on? Yes. Actually, there are more. What we have named are the ones that we use to institute proceedings. Our topic is institution of proceedings. Yes, so these are the pleadings we use to institute a case. There will be pleadings from the defendants on how they reply to a petition, on how they reply to a plaint, but those ones is indeed. For now, we have simply mentioned those that we use to approach the court, to start a case. Yes. Thank you so much, Counsel. Enjoy a fruitful day. We will do as usual when it comes to commercial transactions later in the day. Alafu tukutane kesho, same time. appreciated.